Good afternoon, and welcome to today's webinar, Recent Fair Credit Reporting Act Trends and Updates Impacting Furnishers from Venable. My name is Allison Baker. I'm a partner here at Venable's Consumer Financial Services practice, and I'm really fortunate to be joined by two of my esteemed colleagues today, Jerry Sachs and Alexandra Magaris. And Jerry, if you would please introduce yourself and tell us a bit about yourself, and Alex, same thing.
Hi, I'm Jerry Sachs. I have a great deal of experience in the financial services market, stemming from having worked with the Federal Trade Commission in Atlanta, Georgia, prosecuting civil and criminal cases with the U.S. Attorney's Office in the Northern District of Georgia, and most recently having worked with the Consumer Financial Protection Bureau's Enforcement Office here in D.C., both litigating and investigating cases, as well as helping set overarching strategy and policy.
Thank you.
Good afternoon, everyone. I'm Alex Magaris, counsel in Venable's New York office. I am in our consumer financial services and our advertising law practice groups. Primarily, my practice involves defending companies before the Consumer Financial Protection Bureau and Federal Trade Commission and state attorneys general in various enforcement matters, banks and non-banks, and also counseling these clients with respect to compliance programs and preparation for examination by state regulators and the CFPB.
Thank you, guys. And before we get started today with the program, I just wanted to make a note about the CLE. Continuing legal education credits will be offered for today's webinar, so please stay tuned until the very end, and we'll give you the code which will enable you to get those credits. Information about the certificate that you need will automatically be sent to attendees after today's session. In addition, our webinar today will be recorded and downloadable on our website, and the slides that we will be using will be available early next week, along with a YouTube of this presentation. If you have any questions during the webinar, please submit them through the Question and A widget located at the bottom of your screen. We'll try our very best to answer those in real time. If for some reason we're not able to, we will separately email you offline at the end of the webinar and make sure that we're able to address your questions. And again, please know that we do try to capture all questions to the best of our ability. So this afternoon we're going to be discussing about a few things. We're going to be talking about the Fair Credit Reporting Act just at a very high level, generally, just as a quick overview, and specifically its Furnisher rule. We're going to be discussing what it means to engage in accurate reporting, credit reporting. We're going to be talking about the investigation of disputes, in part how that relates to the strictures of the Furnisher rule. We're going to be talking a bit about what we understand to be regulatory expectations based on recent trends we've seen with respect to the CFPB and also the Federal Trade Commission, some recent enforcement activities. We're going to talk a bit about how you can go about managing compliance, creating a good Furnisher rule policy, and some of the litigation risks associated with all of these different things as they play themselves out in the enforcement world. And so with that, I'm going to turn the slides over to Jerry. If you want to start us off, please, by giving us some background and overview of the Fair Credit Reporting Act as a refresher for folks.
Sure, my pleasure. The first slide here is, if I'm not mistaken, plucked directly from something from the regulators, and it really shows that credit reporting is the backbone of most consumer financial products and services, especially as it relates to any type of lending. And that system relies on accurate reporting for providing a loan, underwriting it, and providing it to a consumer, as well as collecting it on the back end. And so all of it comes into play. We have seen the regulators, both the FTC and the CFPB, for that matter, focus on the accuracy of data and what makes up the credit reporting system. And a lot of it has, in more recent trends, has looked at how disputes are resolved and how information is furnished and how consumers' complaints are treated. We expect that to generally be a recurring trend for the near future. So credit reporting is ubiquitous. Each national consumer reporting agency maintains hundreds of millions of files and data on consumers. More than 1.3 billion consumer credit accounts or other trade lines are furnished on a monthly basis. That's a massive amount of data and how the credit reporting agencies handle it is extraordinarily important, and how it's used as well. Credit reporting is, because of technology, quite frankly, is touching every consumer's lives. It's easier to access, it's easier to use, it's easier to update, and with the availability of everything from credit scores to receiving your annual credit report, whether that's paid for or free, more and more consumers are learning about what makes up their ability to obtain, for example, a loan, a mortgage, an auto loan, small dollar loan, or for that matter, obtain employment or a bank account.
And just to jump in, Jerry, one thing that, a recurring theme, not coincidence, that two former CFPB attorneys are in this webinar. The CFPB has been on the forefront of this issue since day one. And in particular, it has, unlike the FTC, which Jerry will talk about in some detail, it has supervisory authority over pretty much every player in the system. From the slide we just had on before, right? So the credit reporting agencies that are responsible for maintaining the data and publishing the reports, they're supervised by the CFPB. Most of the furnishers in this space, lenders, student loan servicers, mortgage servicers, debt collectors, debt buyers, also supervised by the CFPB if they meet the threshold for a larger participant. And a lot of the users of the consumer reports also are supervised, supervised by the CFPB, and so that gives the CFPB unique access to information and also ability to holistically look at the ecosystem, and therefore a lot of the trends and guidelines that we're going to be focused on today are going to be kind of coming out of the CFPB.
And to dovetail on that a little bit, the CFPB supervises 94% plus of credit reporting agencies, specialty or nationwide credit reporting agencies, and they supervise, the last time I checked, it was 80% or 85% or more of furnishers. So there is an extraordinary amount of supervisory activity that can occur in this space. Of course, the CFPB has somewhere in the neighborhood of 400 to 600 examiners, so it depends on what they can do and where they can get around to. And part of what Alex said with relation to the CFPB obtaining supervisory jurisdiction through the Dodd-Frank Act in 2011 stems from the fact that FCRA was passed into law in 1970 and generally not touched again until the late 90s. And when it was touched, it was sort of tweaked a little bit. There was no complete overhaul of it or no in-depth dive into it. But what it did was amend the Fair Credit Reporting Act was amended to include certain requirements for furnishers, and then again in 2003, it was amended again to address sort of a more modern trend of identity theft. And again, driving off of technology, it was easier to steal people's identities, and so the FTC put out the red flags rule. The jurisdiction over a lot of consumer regulations passed to the CFPB, and that includes Regulation V and updating how FCRA is implemented. And just briefly, the red flags rule covers the fact that every company must have an ability to detect identity theft, prevent it, and mitigate any unlawful activity with relation to it. Of note, it does exclude law firms and healthcare providers. And any type of red flags sort of program has to be commensurate with the size and capability of the institution. And I say that sort of with an asterisk because I have yet to see a regulator say that they really seriously consider that if they find a law violation. They just find the law violation and say you should have caught it. So it's always best to be on the forefront of this and make sure that your IDT or your identity theft prevention program is up to date and continually changing with your business model and with the environment of the industry. And just of note, because this is sort of the low-hanging fruit for regulators to look at, is ensure that you do have a program and that you do have a policy and procedures and that your board of directors has approved it and your board of directors is in the loop on any changes and that your staff is trained initially and then retrained again at some time later after having been with you for a while. And more importantly now is vendor oversight. So, as you're relying more on outsourced assistance to make sure that there is some oversight. It's no longer acceptable to just put in your contracts with your vendors that they will adhere to the law and hope for the best. Regulators are taking an increased look at how vendor management is handled.
So just a couple of points. Regulation V is the Furnisher rule. It's the only rule that's been promulgated to implement the Fair Credit Reporting Act. So the Fair Credit Reporting Act is mostly looked at, unlike some of the other consumer financial laws, its statute is looked at. And one of the interesting things about the Furnisher rule is it does impose a lot of obligations on what we call furnishers, that is entities, namely lenders, but not only lenders, who report to the bureaus, servicers, lenders, et cetera. And I know Alex is going to speak a little bit more about that. But that's really where, from the Bureau's perspective, the CFPB's perspective, that's where the rubber hits the road, because that's often the consumer-facing component part of the Fair Credit Reporting Act that the Bureau in particular cares a lot about. That's not to say that they don't care about the other FCRA requirements, but the Furnisher rule has occupied a lot of their brain power in this space since really 2012, I'd say.
And part of that stems from the fact that the furnishing of information is entirely outside of the control of the consumer's hands.
Right.
So when a consumer has no control over activity that will affect them, the CFPB is going to take a deeper look at that. And depending on how the CFPB changes in the future, they may still continue to look at that because that's something that consumer groups have continually raised as an issue, that when a consumer has no control over their financial well-being, whether that's what's reported about them or how the products work, it raises the risk level of that product.
That's right. And the Bureau is very interested in making sure that every detail of the Furnisher rule is followed. I've seen that as well. And Alex, please walk us through some of the issues relating to accurate reporting and the obligations associated with that.
Sure. So as we're teeing up here, we're focusing on the Furnisher rule and the requirements under the FCRA that the furnishers are subject to. Furnishing is voluntary. That's something that the CFPB and other regulators continually emphasize. But to the extent that you decide to participate in that and do furnishing, you do have to comply with what I think are actually pretty basic requirements set forth in the Furnisher rule. We're going to unpack each of those two major pillars of the rule, but they all have to do with underlying accuracy. What we're not going to cover in today's webinar, and it's probably fruitful for another session, are the requirements imposed by the Consumer Data Industry Association, CDIA, which is the trade association for the credit reporting industry that sets the standards for the electronic data reporting formats so that the information between the furnishers and credit reporting agencies gets sent correctly and mapped correctly, et cetera. Those rules are very complicated. It drives a lot of the day-to-day work of those that work that do the furnishing on behalf of furnishers. Again, it's outside the scope of this webinar, but I plant that seed because we are increasingly seeing, mostly on private litigation, not so much on enforcement, that non-compliance with these Metro 2 or the other CDIA requirements can result in allegations, at least, of violations of the FCRA, meaning if you don't report in accordance with those rules, you're not reporting accurately and therefore potential risk for the core rule. But again, outside of this scope of this webinar.
And just to chime in there for a second, it's not outside the norm of regulators to say if you're not up with the industry standards or the industry norm, it's an unfair practice. And we've seen the FTC do that in everything from data security and privacy to other cases, and same with the CFPB. So to the extent you're not familiar with the reporting requirements or the trade association's rules, we encourage you to get familiar with those.
So the accuracy of the data that's maintained by the credit reporting agencies is, of of course, the foundation on which a credit-based economy relies. Financial institutions depend on the reliability of the data in order to determine the appropriate risk-based credit to offer, and in turn, of course, the reliability of that information greatly impacts individual consumers and their day-to-day lives. As a result, the Furnisher rule has been broken down into two main components, all of which are driving at accuracy. And the first is the obligation to report accurately. So under the FCRA and the Furnisher rule, it's illegal to report information that you know or believe is inaccurate. So you have to have actual knowledge of inaccuracy in order to be in violation of this requirement. One has reasonable cause to believe that the information is inaccurate if the organization has knowledge, other than the allegations from the consumer, that would lead a reasonable person to doubt the accuracy of the information. So when you think about, not reporting inaccurate information, the question is, what affirmative obligations do furnishers have? And the main one is really making sure that your data governance and quality control programs are robust enough, are working in order to ensure that the information that's furnished reflects the information that's in your organization's system of record at the time the credit report file is made. So when we talk about, knowing that something may be inaccurate, really what we're looking at there is whether or not there's enough investment and reliability in the systems that drive reporting. So if the data fields, for example, are not matching up between, what is in the system of record that reflects the status of an account, for example, and what goes out to the credit reporting agency and shows up on the consumer report, that's going to be considered to be knowing that the information is inaccurate. If an organization furnishes information to a credit repair agency on a regular basis and thereby determines afterwards that any information provided is inaccurate or incomplete, there's also an affirmative obligation at that point to promptly notify the credit reporting agency and update or correct the information or make it complete to the extent the issue is that it's incomplete. And then going forward, you may only continue furnishing the correct information to the CRA. And one kind of additional element to this is it's important that if something is identified as inaccurate or incomplete about a trade line or the information that was furnished to one CRA, you have to make sure that that information also is properly being reported to the other CRAs that your organization may be reporting to. So you have to take a more holistic approach when you identify potential issues. This FCRA, again, it does not mandate furnishing. It's voluntary. And there are very few requirements with respect to if you decide to furnish, what exactly you must furnish. Only a few areas where the statute and the rule are expressed. And that's one, credit limits. You must include the credit limits if that information is applicable to the trade line. Second, and this is an area that we will spend a considerable amount of time on, as Jerry flagged for us at the beginning, is disputed information. Once a consumer disputes information on his or her credit report, you as a furnisher that receives a dispute may not continue reporting information to the CRAs unless you identify that trade line as being in dispute. And one area where I spend a lot of time counseling clients is, at what point can you remove that dispute flag? If something once disputed indefinitely, at what point can you consider the issue resolved, right? So we'll talk about the obligations to investigate disputes. But the question posed oftentimes is, after the investigation is complete, we meet our obligations on that front. Can we continue to report the information without the dispute flag? And that's a kind of a gray area. I think every organization looks at it differently. But the risk of doing that, where there's not a meeting of the minds between you and the consumer about whether it's been in fact resolved, the dispute has been in fact lifted, can cause some risk. You need to be careful about how you, after conducting an investigation of a dispute, how you continue to report that information. And then finally, if you furnish information on a regular basis, you must notify the credit reporting agency as part of your routine furnishing if a consumer has voluntarily closed an account. Another area that's expressly spelled out in the FCRA with respect to affirmative obligations on furnishing relates to delinquent accounts. And so when an account is referred to collections or written off, charged off, for example, you are required to notify the credit reporting agency to the extent you're reporting that account that you have done so, and must also report the date of first delinquency to the credit reporting agency within 90 days. This date of first delinquency is extremely important. If you look, and we'll discuss a little bit about kind of the guidelines and other publications regulators have issued over the years, a lot of ink has been spilled on the date of first delinquency. It's important because it determines when information on a consumer report becomes obsolete and therefore may no longer be reported. So as I'm sure most of you know, a delinquent debt can only be reported on a credit report for 7 years, and a debt discharge in bankruptcy for 10 years. That's kind of really the only outside limit other than inaccuracies that governs when something has to come off a report. And so for that reason, there's been a lot of focus on making sure that the date of first delinquency not only is reported, which is required, but that it's accurate. And the Federal Trade Commission, might even be 20 years now, issued guidance to business organizations that are furnishing and spelled out kind of based on what the rule says, that if you are also the collector, the party that bought a charged off debt, for example, the obligation also is to report that date of first delinquency. And if you don't receive the date of delinquency from the creditor, there are alternative means by which you can calculate it yourself and report it, report it even though you didn't receive it from the original creditor when that file or when that account was transferred over. That said, while that is permissible, we'll get into a little bit, the CFPB has recently kind of flagged that as a potential issue. So not receiving the date of first delinquency from the original creditor should be a reason to look at those files more carefully. So while it's okay to report it based on the calculations that the FCRA sets forth, the CFPB is saying, yeah, but you really need to take a second look at that information. Why is that information missing? Is there other things that are potentially inaccurate? And we'll talk a little bit more about that later in the presentation. But I raise that because it seems a little inconsistent with not just statute, but prior guidelines issued by the Federal Trade Commission.
Let me ask you a question, Alex. Date of first delinquency is an issue that, to your point, a lot of ink has been spilled over, and it's mission critical for anybody in the collection space in particular. Can you just briefly talk a bit about why that's so important? I mean, you mentioned it here with the 7 years, but a lot of, I have been involved in cases, litigation, that focuses on receipt of DOFD and how you assess what that date is.
Well, so it's a couple things. So one, a lot of entities trip up with respect to changes in a status of an account post-delinquency. So, for example, after an account becomes delinquent, a lot of other things can happen. So, for example, the consumer can file for bankruptcy. And oftentimes the way a system of record is designed, either inadvertently or by design, the date of first delinquency will be substituted or updated with this future event. So if, let's say, it's a filing of a bankruptcy. And so then the next credit file that's cut and sent to the credit reporting agencies reflects a date, more current in time. And so that's re-aging of the debt. So instead of reporting that the account went delinquent, a year ago, it's now showing the date of bankruptcy filing, and now the trade line will be on the consumer report for an extra year. And so, of course, for all these reasons, one, that's inaccurate, but also it could have negative consequences for the consumer because it's derogatory information, and collections trade lines and delinquencies, of course, factor into credit score and otherwise looked at negatively with respect to a consumer's creditworthiness. And so that's why it is a focus, because it's very easy to get it wrong, because there are other things that are happening in the life of an account that can cause that date to change. And also it directly and immediately impacts that individual's report, because it has a very big impact on credit scores and other credit factors that lenders will look at. Another somewhat unique aspect of Regulation V is that it expressly requires that furnishers establish and implement written policies and procedures regarding the accuracy and integrity of information that's furnished. Policies and procedures and compliance management, of course, are important for ensuring that your organization can prevent and promptly detect and remediate potential violations of law. And for furnishers that are subject to supervision by the CFPB or state regulators, compliance management policies and procedures are always reviewed, but it's typically considered, a prophylactic measure. Here, the lack of written policies and procedures are a standalone violation of the regulation. I think 5 CFPB enforcement actions where the CFPB found, alleged a standalone count or claim that there were not, reasonable policies and procedures at the furnisher to ensure accuracy. The rule specifically references Appendix E to the regulation and directs furnishers to consult those guidelines set forth in Regulation E when creating their policies and procedures. And one of the guidelines in Appendix E is that policies and procedures should address, furnishing information about consumers following transfers of accounts in a manner that prevents re-aging, which is what we just discussed. The transfer of accounts, whether it's a servicing transfer or a debt sale, has been something that regulators have been laser focused on, because it's in those when accounts are transferred from system of record to system of record or entity to entity, oftentimes documentation and records change, and the pipes are not always properly connected, and you can map one data field to, from one system into a different data field, another system, and all of a sudden you have the wrong, for example, date of first delinquency. And so the directive in the regulation is that furnishers must have procedures in place to address situations where information that's absent in an incoming loan servicing or loan sale data file is flagged and dealt with. And this is where I mentioned a few minutes ago, the CFPB has, in its supervisory highlights, has highlighted that date of first delinquency being missing from those data files is something that needs to be addressed. Now, again, I don't think they're saying that you can't calculate that date of first delinquency pursuant to the FCRA's formula, but that it raises an issue with respect to potential accuracy issues. Another guideline relates to record maintenance. Furnishers are required to maintain records to substantiate the accuracy of furnished information that's disputed for a reasonable time. This includes a record of the investigation that was conducted of the dispute. This is something I think that's very much overlooked, right? So how do you memorialize the investigation that was conducted? And what does that look like if you have to, in 3, 4, 5 years, prove that the investigation not only was conducted, but that it was reasonable? And with respect to kind of a reasonable time, I think, record management is an entire webinar in and of itself, but certainly for the length of time that the organization is furnishing an account, you should maintain those records, but also at least 2 years afterwards, which is the statute of limitations for private claim under the FCRA. And then another area that I'll highlight with respect to Appendix E's instructions to furnishers with respect to policies and procedures is that furnishers should have a procedure to incorporate feedback received from the credit reporting agencies. Those that are engaged in credit reporting know that this is very data intensive, and it's an exchange of files from the furnisher to the credit reporting agency. And then on the CRA side, there are a series of quality control checks and other checks to make sure that the data conforms to their standards. And oftentimes what gets kicked out is an exception report. And I think historically, furnishers looked at those exception reports as just a kind of a data maintenance or hygiene issue that's between them and the CRAs. I can tell you I've worked with clients through exams where the CFPB in particular requests those exception reports and tries to extrapolate, were these flags, were these exceptions that the CRAs found addressed? In other words, did you incorporate these issues, whatever was flagged, so that the next round of furnishing does not result in those same exceptions? So that's something that I think a lot of entities just didn't take into consideration with respect to using those exception reports to do some type of root cause analyses. The second pillar in terms of the obligations on furnishers built into the FCRA and the regulation also is geared towards promoting accuracy and fairness of the integrity of the information, but it's kind of a reactionary. It's how to respond when a consumer essentially raises her hand and says, there's something wrong with the information on my credit report. The FCRA gives consumers the right to dispute the accuracy or completeness of any information appearing in the credit report, either with the CRAs, referred to as a indirect dispute, or directly with the furnisher, referred to as direct disputes. One thing I want to just note, and you'll see in the third bullet here, for debt collectors in particular, this is kind of a complicated area because it partially overlaps with other obligations under the Fair Debt Collection Practices Act. Specifically, the FDCPA 1692G has a provision that gives consumers the right to dispute or seek validation of the debt or obtain information about the original creditor. And it includes very specific obligations on the debt collector if it receives a dispute in writing and within 30 days of sending the consumer what's called a G notice. And so it's different. It triggers a different set of obligations. And oftentimes when you receive a dispute, it's not apparent if a consumer is invoking her rights under the FDCPA or it's a response to what she saw on her credit report. Sometimes it's both. And so a lot of companies, collectors in this space, have had issues trying to harmonize those two set of obligations and have inadvertently kind of try to create a policy that tries to deal with both, but doesn't actually work because they're using, for example, the 30-day cutoff that artificially cuts off FCRA disputes, which is not subject to a 30-day period like the FDCPA, et cetera. So it's just an area that I know the CFPB has honed in on. After all these years, I still don't know if the CFPB did it by accident or by design, but it's something that they have logged onto with respect to collectors, and are you properly addressing disputes under both statutory regimes?
And having been at the CFPB, I will say the answer to that is yes.
Exactly. So as I mentioned, consumers can dispute with the credit reporting agencies, and then the credit reporting agencies typically just forward that dispute to the furnisher through the eOscar system, which is an online portal that allows the CRAs and furnishers to communicate with respect to disputes. Once you as a furnisher receive a dispute through the eOscar system, you absolutely must investigate the dispute and review all the relevant information that comes inbound from the CRA, report the findings to the CRA, provide any corrected or updated information to every CRA that receives the information if the investigation bears that the information was actually inaccurate or incomplete, and then modify the information, delete it, or block the reporting if you can't verify whether or not the information is in fact accurate. And this all must be done within 30 days. If you can get 15 more days if the consumer provides additional information. For many entities in this space, especially larger companies that are dealing with a lot, high volume, this results in a lot of disputes. Technology and the credit reporting agencies, being under a lot of pressure, have made it very, very easy for consumers to file these disputes online. It doesn't take much, and so a lot of entities are dealing with a huge volume of these inbound eOscar disputes. And for a while, I think, in order to deal with this short time period, a lot of companies were saying, well, we'll just delete the trade line. That's what the consumer wants. It's a consumer-friendly solution. We don't have the bandwidth to properly investigate all of these eOscar disputes, and the CFPB a few years ago said, that's not okay. The investigation process in and of itself is valuable. It's not about just dealing with Jane Smith's trade line. If you're getting disputes, you need to be investigating them because it could surface issues with respect to the reliability of the information. Something might be broken in your system, or something might be wrong with the underlying data. So you can't just delete a trade line in lieu of the investigation.
And that goes back to sort of an earlier point you made, which was the regulators want you to find the root cause of any issue. And so if something could be systemic and you don't discover that because you're not thoroughly investigating disputes, that will raise issues for you.
Absolutely. And then direct disputes. So consumers have the right to dispute directly with furnishers. If this is where things get different between direct and indirect disputes, if the nature and form of the dispute meet the specific criteria in the FCRA, which we'll discuss, then the furnisher is required to, again, investigate the dispute, report the results to the consumer within 30 days, and then to the extent something was identified as inaccurate or incomplete, notifies the CRA and updates the information. The second bullet, report the results to the consumer within 30 days. This is an area that I think, because a lot of the issues with respect to accuracy and furnishing and handling of disputes has been more or less addressed. This is an area that the CFPB has been focused on very recently. Are the notices going back to the consumers sufficient? I think the CFPB is very critical of form letters. So where, after you complete your investigation, if you're sending back a letter that says, dear consumer, thank you for your dispute. We have done an investigation. Everything looks good. Sincerely yours, Furnisher. That's not going to fly. And the CFPB has called out many organizations through its supervisory highlights, saying that there needs to be a lot more specificity tailored to the consumer-specific dispute, the specific findings of the investigation. So that's an area where we kind of think through potential gaps or weaknesses How good are your outbound letters, and are they going out in the first place?
Alex, you've spoken a bit about the intersection of the Fair Debt Collection Practices Act and the requirements of the FCRA and Reg Z, and I'm wondering, when you've spoken about that, if you could give us some sense of how you're thinking about the concept of what a debt collector is. Is it debt collector as defined within the FDCPA, or are you imposing a broader definition?
Well, in terms of the triggering of the validation requirements under the FDCPA, that definition governs, but the definition, I don't think the FDCPA defines debt collector.
It doesn't.
Debt collection.
That's right.
And that's very broad. It's pretty much anything that would be any type of communication or effort, including credit reporting, considered to be an indirect way of trying to get repaid, where a consumer is past due, or it doesn't even need to be in default to get repayment. So that would be very broad under the FDCPA. And then, of course, the FCRA dispute dispute handling requirements that we're discussing right now applies to any furnisher.
And for debt collector itself, so the concept of a debt collector, although not specifically defined in the FDCPA, but it applies to third-party debt collectors as opposed to first-party, at least as of now.
So the FDCPA only applies to third-party collectors or first-party collectors not collecting in their name.
Right.
But, just to be clear, that is 100% accurate. However, the regulators will generally use UDAP.
That's right.
The first-party collector that is effectively violating the Fair Debt Collection Practices Act, should it apply to them.
Or the strictures of that act. They'll impose it. I mean, and that's something the Bureau's been doing for a long time, which is kind of using UDAP as a gap filler, if you will, for lack of a better way to think about it. And, of course, we're expecting new rules on this issue as well, which we can talk about at the end if we have some time.
And it's also something the FTC did before CFPB, so it's been around quite a while.
Yeah. Well, one last thing on the FDCPA and the validation notice requirements. I have not seen, for example, the CFPB say that first-party collectors must send a G notice that includes the very specific, disclosures and articulation of rights. But I can tell you that if a first-party collector is receiving disputes, if a consumer is disputing that the information that the entity is saying about the underlying debt, the amount, for example, if it's wrong, and the first-party collector is not responding to that dispute appropriately, while it won't violate the specific requirement under 1692G, that could be a UDAP, and I think that's where Jerry was going. So as I was, a few slides ago, I said essentially if you receive something through eOscar, if a CRA forwards a dispute, you have to investigate. There's no analysis in between receipt of the dispute and your obligation to conduct an investigation. Direct disputes are different in this regard, in that only if the dispute itself meets certain criteria is the obligation to conduct an investigation triggered. And so this gives furnishers the ability to essentially review the inbound dispute and make an assessment as to whether or not there has to be a response. A consumer's dispute must be investigated if the dispute relates to the consumer's liability for a credit account or debt, the terms of that credit account or debt. So, for example, if it relates to the principal balance or the payment amount or the credit limit, that would fall under the terms of the credit account. Third, if the dispute relates to the consumer's performance or other conduct concerning the account. So if the trade line says that the consumer missed a payment, that will be something that has to be investigated. And then finally, any other information that bears on the consumer's creditworthiness.
I wanted to ask you a question about this as well, in terms of consumers directly disputing components of their report based on Furnishers' conduct. consumers sometimes send these in all the time, right? You sometimes get some consumers who send in these disputes monthly. What are your thoughts about how you manage that and kind of, strictures around that? I mean, I don't think there are any. I think it's really
So I could just skip to this next slide. So again, in the direct dispute world, where the consumer is writing the furnisher a letter and says, "I'm disputing this," if the consumer has filed substantially the same dispute before, and you as a furnisher completed your investigation, and there's no new information in the second, third, fourth, fifth, sixth dispute, you do not need to conduct an investigation. You do need to respond to the consumer, and within 30 days explaining to her, why there's not going to be an investigation, but you don't have to do the investigation. In the indirect dispute world, where you're receiving them through eOscar, and this is where the high volume really is, you don't have that discretion. You still need to respond. I think, practically speaking, assuming not much has changed in the account, typically these are non-paying accounts, and if not much has changed, then the investigation will be streamlined, easier, the second, third, fourth time. But you do need to engage in that. That requirement still exists. And so, again, in terms of what does not need to be investigated, if it's a direct dispute, duplicative disputes, but also if the consumer did not provide enough information so that the furnisher can actually do its job and investigate. I would say that it's really hard to implement a policy or procedure that that defines the line between what's enough information and what's not enough information. Obviously, if you just receive a letter that says, "Dear Furnisher, something's wrong with my credit report," and signed, Mrs. Smith, that's not going to be enough information for you to do an investigation. But I think almost all of these disputes, a lot of these disputes are form letters that can be found by doing a simple Google search, do include the basic information about the trade line and the consumer, identifying the consumer, that will allow you to do some basic investigation. So it's really, I find it very difficult to actually implement this first kind of prong of frivolous or relevant. But certainly when you're talking about identical disputes, that's easier to operationalize. So what is a reasonable investigation? Even reasonable is not part of the statute. It's been read into it through court decisions. It's not defined. The CFPB issued a bulletin in 2013 that says essentially every furnisher is required to review and consider all relevant information relating to the dispute. That's not particularly helpful. The next clause but it's the minimum, including documents that the CRA includes with the notice of dispute or transmits during the investigation, and the furnisher's own information with respect to the dispute. The challenge really has been that most of these inbound disputes, and this applies to both indirect and direct disputes, I should note, the standard with respect to investigation, has been that most of these inbound consumer disputes are very vague. Where consumers have, very specific issue. I paid this on the 15th of October, so therefore my balance is actually $100 less than what you reported on my November trade line. Easy to investigate. It's easy to train someone to look up the consumer's account, figure out, was that payment received? Was it applied? Was this about when the file was cut for purposes of reporting it to the CRAs, or was it some other blip, etc.? Was it a check bounce? There's a lot of things, but it's an easy dispute to handle. Instead, as I think many of you listening will understand, you're typically receiving eOscar disputes that just say "not mine," and that's the first code a consumer can select in the drop-down menu when submitting an electronic dispute, and that's the only information you're getting other than identifying information about the consumer and the trade line that you've been reporting. And so I've spent a lot of time working with clients on trying to come up with the right-sized investigation for something vague like not mine. It's hard, but there are definitely information that's in your system of record, a review of account history, account notes, payment information, bumping up against what was reported to the credit bureaus, and also any other information that the consumer has conveyed to you over the course of your relationship with her. So, if she had called in explaining that a payment would be a little bit late, make sure to take that all into consideration and not just matching the specific information on the trade line against the information in the system of record. That's really what the CFPB was finding entities were doing, and was trying to counteract that very rote matching, one data field to another data field, and not taking the whole account history into account when doing the investigation. And with that, I will turn it over to Jerry to spend a little bit more time talking about kind of regulatory expectations and enforcement activity and what we can learn with respect to furnishing.
Great, thank you. So just before we get to this one, I wanted to note one piece of information that is not in our slide deck, which is the CFPB highlighted FCRA's requirement that specialty credit reporting agencies have a streamlined process for obtaining a free credit report. This was sort of, again, an easy thing for the CFPB to point out, which was basically that you have to have a clear and prominent piece of information on any website owned by the company or maintained by the company, which is a toll-free number of how to obtain credit report, at least at a minimum. And basically, again, this ties back into furnishing of information. Why do you have to have that information on your website? It's because the CFPB wants consumers to be able to dispute stuff. So now moving on to recent bulletins. And what I'll do is I'll walk through some of the recent bulletins and then move on to enforcement actions from the CFPB, the FTC, and some states, and discuss sort of where we think the regulatory power will come from in the next couple of years, whether that will be the CFPB or the FTC. I do have an opinion on that, as I'm sure others in the room do, and probably many of you on the phone as well. So first, looking at the December 2012 report issued by the CFPB. I'm not going to walk through the entire report. It's 48 pages. It is a thrilling read. It's something you want to have on your nightstand just before you go to bed. So I encourage everyone on the phone to take a look at it. Again, this report really hit on some issues that the CFPB found were affecting consumers, and of course, it related to the furnishing of information. It focused on inaccuracies and the variety of reasons why those can occur. To the CFPB's credit, they did note that consumers can make errors on credit applications, and that can factor into their credit report. But again, if they do dispute that and they provide information and correct that information, then a furnisher would have to, and the CRA would have to take that into consideration. The CFPB also noted that creditors can sometimes make mistakes, whether that's, for lack of a better way to put it, fat fingers on a keyboard, mistyping a number, or just writing something down in error. Furnishers can create errors. And so all of these should be taken into consideration. By far, though, the CFPB noted that the largest number of disputes stemmed from the debt collection industry, which was about 40% of disputes. However, I would note that's probably the largest group of furnishers. So not entirely surprising. I will note that sometimes the CFPB states things that appear to be rather obvious, and they come off in certain lights that tend not to be the best.
And I would argue that also there's a context issue there, right? I mean, an absolute number doesn't really tell you very much if you're talking about a company that underwrites, 15,000 mortgages every 2 months,
Right. A lot of that is not taken into consideration when raw data or reports are pushed out, especially by the CFPB. Sometimes they're a little bit more balanced when they come out of, let's say, the Bureau of Economics at the Federal Trade Commission, but time will tell if that balance shifts back. The CFPB's report did note a few things about the Furnishers rule that Alex just covered. And the one thing that all regulators look at, and I think it's worth noting again because it's quite frankly overlooked a lot of times, especially with startup or financial technology companies, and that is have policies and procedures that relate to the accuracy and integrity of whatever is being furnished or how you investigate it. It's really simple to do, but sometimes it's overlooked, and that is an easy law violation. And again, those policies and procedures have to be commensurate with the size and scope of the business. The CFPB noted in its report, just a couple of other areas I will cover, are sort of inaccuracies. And the ones that they noted that are sort of sometimes outside of the consumer's control are mixed files. So reporting something on furnishing information to the wrong consumer, or, in my case, I have a twin brother, and so sometimes he finds my credit information on his credit report. I'm assuming we're one Social Security number away, but he informed me, for example, that I got a speeding ticket in Virginia when he was going to get a car loan. And I found that quite funny, but, I was also a little upset that he knew about my driving record. So some of that stuff does happen. The CFPB also noted misrepresentations on status of trade lines or on accounts. So another thing to check when you're reporting is the line closed? How was it closed? What is the status? Is it delinquent? Is it now non-delinquent? And again, the CFPB noted that a lot of it stems from really looking into the trade line and understanding whether it was an ownership issue or an authorized user, whether something occurred because of failure to post a payment, or again, assigning to the wrong count or a failure to update. One of the trends that I've seen from the CFPB and from other regulators is that if you do advertise anywhere that you are improving or helping consumers build credit, you need to ensure that you are in fact reporting their credit. And I'll talk about that with an enforcement action that the CFPB took. We'll discuss that in just a bit. Moving on to the next slide. The CFPB has taken a unique look at many things, and one of them is reaching out to credit reporting agencies and basically saying, tell us who is not doing things correctly. And so the CFPB is expecting CRAs to provide regular accuracy reports as part of their ongoing examinations and basically saying, these are the furnishers that we think have a lot of issues. And whether that's because they're not investigating things or whether it's because they're investigating things too quickly or they are just reporting or have a technology issue. So, but either way, if you're furnishing information and you have a high level of disputes, you can expect the CFPB to be interested in you, and they may not find that out through consumer complaints. So just checking the CFPB's portal won't do it. The CFPB is obtaining this information from other sources and evaluating how best to do it. And I will note, though, that this provides only a very limited snapshot, but it might put you on the receiving end of a civil investigative demand from the CFPB. And I say that because if you, for a couple of days, have a technology issue and you're misreporting something, but then you correct it, you may peak up on the CRA's list of being a furnisher that has a high level of disputed information. And again, it could be from a technology issue that could be remedied overnight, but again, the CFPB is likely to come asking questions.
Yeah, I can't emphasize how important Jerry's point is, and it harkens back to the first slide where we said CFPB is unique because of its supervisory authority. So it's examining the CRAs and learning a lot of information in turn about the furnishers, including furnishers that are not part of the supervision program. And this group of a multi-state, about May 2015, settled the CRAs, and part of that settlement agreement also required the CRAs to put together a working group to get together, I think, quarterly, and just share analytics about which furnishers have the highest disputes or the most issues with respect to formatting and meeting the credit reporting format standards and to share that information with the states, but also to create reports that in turn will be probably shared with other regulators, including the CFPB. So there's a lot of kind of transparency and a lot of everyone's checking each other.
And what's interesting also that stems from that is, the CFPB is going to gain information about furnishers it does not have supervisory jurisdiction over, but nonetheless has enforcement jurisdiction over. And on top of that, the CFPB coordinates with a number of states. It has a group of friendly attorney generals that it shares information with. So if either now or in the future the CFPB cannot take action based on furnishers that don't fall under its supervisory jurisdiction, we can expect that they will refer that to friendly state attorney general's offices or over to, depending on the activity, to the Federal Trade Commission or a U.S. Attorney's Office that could be friendly. So moving on to the next slide, which is CFPB supervisory highlights from 2017. And I will touch this as briefly as I can so we can move on to enforcement activity. But the winter highlights of 2017 focused on compliance management systems. And, that's not really surprising because the CFPB has supervisory jurisdiction, and that's what they look for. Do you have a compliance management system, and is it appropriate for your business, and do you have oversight? And the things they noted are all things that we've talked about recently, which are oversight of your furnishing, and is it accurate, reporting, of course, by the CRAs on furnishers and dispute status. Is there something that tracks that if you're a CRA? If you're a CRA or a furnisher, are you tracking consumer complaints? Are you tracking how you use third-party records? So if you're integrating public records or third-party records, most people would say, well, it's a public record. I'm not doing anything. I'm just reporting this public record. But the CFPB wants you to verify that that public record is actually authentic and verifiable and accurate, not just that you're plucking it from the ether and putting it into a consumer's file.
And one point about this is the CFPB has taken action against entities that are not consumer financial services companies using this prong of FCRA, which is really interesting and candidly a little controversial because you don't need to be a provider or what's called a covered person, an entity that provides or offers consumer financial services or products to consumers to come under the FCRA statute and or authority that the Bureau has. So it's something to keep in mind. You could easily be brought into this by virtue of simply providing something that is a publicly reported piece of information for a background report, for example, because the FCRA covers that. So something that we've seen at least once in an enforcement action.
Absolutely. Some of the other information covered in the supervisory highlight related to ongoing monitoring of vendors for CRAs. That could be furnishers for furnishers. That could be a variety of debt collectors across the country, our agents. And, what are you doing with regards to that? Interestingly, in this 2017 highlight, the CFPB noted data security standards and re-vetting and acceptance of data and how it's being undertaken. I will note that the CFPB does not have direct Gramm-Leach-Bliley authority to investigate data breaches and security. However, under Gramm-Leach-Bliley, they do have the authority as it relates to privacy notices. Nonetheless, the CFPB and the FTC and various states and the prudential regulators have all used UDAP to go after data security issues. A couple more interesting points from the supervisory highlights, and again, we encourage you to read them. But the CFPB noted that furnishers should get feedback from the CRAs. So you should be, if you're furnishing information, you should be in communication with the CRAs. And if they are sending you information or have a different take on a dispute that you have investigated, you should have some communication to ascertain that. The CFPB also wants to ensure that both CRAs and furnishers are communicating with consumers. So are you keeping the consumer well informed? The CFPB has tried to make this easier through their consumer complaint portal. Not clear how effective that has been. The CFPB also notes that at every level of a compliance management system, the board of directors must be involved. They must approve your compliance management system. They must be kept up to date on any issues that relate to compliance. They should be updated at minimum quarterly as it relates to consumer complaints. Are you monitoring, for example, an uptick in consumer complaints or any types of issues? The CFPB noted you must have a data governance program, and you must update your policies and procedures. So, this goes along sort of hand in hand with training, updating your policies and procedures and retraining and training and training your staff as your business model changes, or as you get new information, or as you have a new prong to what you're doing. Or even if it's the same old business, just taking another look every now and then and making sure everything is appropriate. For example, tracking disputes and complaints. The last note in the supervisory highlight, and something that I think is always sort of, that is something regulators are looking out for, is whether credit reports are being used for permissible purposes. And I think this can affect both furnishers and credit reporting agencies. In the furnisher side, are you obtaining, are you furnishing information appropriately? Let me rephrase that. It would apply on, and I say the furnisher side because a lot of furnishers also use credit reports. So are you obtaining it with the consumer's consent or as allowable under the law? Interestingly, the CFPB seemed to take issue with credit reports that were obtained under false pretense. And I'm not sure how a credit reporting agency would be able to stop that from occurring. It's very hard to stop criminal behavior. The CFPB doesn't seem to take issue with that, but they seem to note that that's an issue that CRA should be on the lookout for. So moving along into enforcement of FCRA. As we noted earlier, traditionally FCRA was enforced by the Federal Trade Commission. The CFPB under Dodd-Frank gained enforcement jurisdiction and supervisory jurisdiction. That doesn't mean that the FTC is letting up on it necessarily. This is an area they've been heavily involved in for decades, and it's not something that fades lightly. I will also note, for anyone on the webinar who knows the personalities of the CFPB and the FTC, that one of the key people at the CFPB handling credit reporting issues was Tom Paul, who is now the Consumer Protection Director at the FTC. So there is experience that was once at the CFPB and now has gone back to the FTC. Notwithstanding that fact, the CFPB did take some attorneys from the FTC that were extraordinarily knowledgeable in this area as well, and they are still with the CFPB. But I just raise that because I don't think that the FTC is going to sort of have a lull in looking at credit reporting. Their focus, though, in the short run seems to be more on how employers are using credit reports, and do you have everything that you need as an employer to get that credit report? Do you have something in writing? Is it authorized? Have you provided the appropriate disclosures under both federal and, quite frankly, state law if it's required? This is something, again, that a consumer has very little control over, and that is how an employer uses their credit report. And so the regulators are taking a look at both what employers do, but also how screening companies that are contracted by employers and what they are doing. So there's two other cases that I'll mention from the FTC, just looking back into 2016, 2015. That one relates to adverse action and risk-based pricing rules. So if you're providing someone with for lack of a better way to put it, not as great or not as ideal credit terms as advertised because you're doing risk-based pricing, are you providing the consumer with information that you are doing that based on the risk-based pricing and their lack of stellar credit, again, for lack of a better way to put it. Regulators are always interested in, if you're using credit reports, are you providing adverse action notices if they're required? And I say if they're required because it depends on the action that you take. And finally, there was a 2015 case that the FTC brought on, if my recollection is correct, a small auto dealer that didn't have policies and procedures on furnishing information and handling disputes. And so that's something, again, if you're furnishing any information that you want to be aware of, and at a minimum develop some policies and procedures. Moving on to the CFPB. The CFPB has, as we mentioned, the supervisory authority, which gives them a great insight into this area of credit reporting and also furnishing. The CFPB took issue, and I'll start with some from 2016, but one was with a fintech online lender, and the CFPB essentially claimed that while they advertised they were helping consumers build their credit, they weren't reporting positive trade lines for 2 years, and that they failed to have written policies and procedures to ensure the integrity of the information that they were furnishing. So again, anytime you as a business are advertising that you are building credit or helping consumers build credit, you want to make sure you're reporting those trade lines. And I won't walk through sort of all the civil money penalties because it's all available online, and we're happy to follow up with anyone who wants sort of a deeper dive into any of this material. The CFPB took issue with, again, a debt assistance program and I say again because it was claiming that it could improve people's credit scores and was not reporting appropriately. The CFPB has looked at both non-banks and banks. The fintech lender was a non-bank. The debt assistance program was a non-bank. The CFPB also looked at a national bank because of how they were screening for checking accounts and the information that they were using and how they were reporting and the lack of policies and procedures to ensure that that information was accurate and the lack of ability to handle disputes related to denial of checking accounts based on that information. The CFPB has taken issue with all three of the credit reporting agencies based on the use of an advertisement of credit scores and products associated with credit protection or otherwise. The CFPB has also taken issue with mortgage servicing companies for not accurately reporting past data on mortgages. So if you're, whether that's reporting your own mortgages or transferred mortgages or someone else's, you want to make sure that you're doing that correctly. The states have been active, and I would expect them to continue to be active in this area, especially with the inevitable change of the CFPB either one day from now or 9 months from now. And I would expect that the states will pick up a lot of that slack. I think many of the states have not made a secret that they plan on doing that. For example, California, New York, Illinois, Massachusetts, North Carolina, and potentially even states such as Mississippi. So many of these states have been involved in 2016 and 2017 with multi-state settlements or their own state settlements, and they generally relate to the accuracy and when I say settlements with the CRAs relating to the accuracy of information and the ability for consumers to obtain their free reports. So states are looking, and the CFPB and the FTC are looking at the CRAs, and they're also looking at the furnishers and how they're reporting information, how they're using it, what you're marketing and how you're marketing it. And I would be remiss if I didn't I'd be remiss if I didn't mention the prudential banking regulators, who obviously are looking at the banks and how they're collecting and furnishing information with relation to delinquent or defaulted or written off debt. And so if you're doing any of those practices, there's plenty of things that you want to ensure you are doing correctly to stay on the right side of your regulator.
There's something you mentioned earlier, Jerry, that I was hoping you'd come back to, which is vendor management or service provider management. And this is something that the CFPB and the OCC in particular have taken issue with and have been very vigilant about watching out for and monitoring, which is namely, it's not enough for you to have in place certain protocols, but let's say you have a service provider who is, servicing your debt, and arguably maybe they're a service provider, maybe they're not, but they're nevertheless someone in your orbit. What kind of policies and procedures do they have in place? What kind of furnisher dispute resolution mechanisms do they have in place? And how does that reverberate back to you if you're primarily regulated by the Bureau or OCC? And I don't know how much of that, we haven't seen a lot of those actions, but it's definitely something that banks and non-banks are examined for pretty carefully by the Bureau and also by OCC. So, I don't know if you have anything you want to add to that, but.
Well, so it's interesting. Service provider oversight used to be generally based on the risk of the service provider and the risk of the product. So if it was a riskier product, maybe you had to have more oversight. If it was a small product with a lot of risk, then maybe not as much oversight. If it was a large product line, higher or low risk, maybe more oversight. But the CFPB has generally said, we don't care about that issue. We don't care necessarily about the risk of the service provider. We care it's a service provider, and you need to go oversee it. I'm hesitant to say something along the lines of you need to do a physical site inspection of all of your service providers, but that almost seems to be the standard that the CFPB has pushed people and the FTC to a certain extent, because if you don't know that your service provider is a legitimate company doing legitimate things with great policies and procedures, board reporting, then your service provider may draw you into the trouble. The CFPB, obviously, and I've seen them do this a number of times, they lack jurisdiction over smaller banks, but they will go after the service providers to those smaller banks. And depending on the product, that may in turn come back to hurt the reputation of the bank, depending on the product, and then that may draw your prudential regulator as a smaller bank back into the mix to question things. But I have found that there is a difference between service provider oversight or vendor oversight among the regulators. The FTC and the CFPB look at it one way, and the prudential banking regulators seem to take another. I'm hesitant to say, but I think it's more reasonable look at service providers. But it really depends on the industry and what's going on. But nonetheless, all of them at the federal level have said, if you have a vendor doing work for you, you're definitely responsible for their work, and you must have some type of policies and procedures and actual oversight of it.
Yeah, so where I think the service provider issue comes up most commonly when we're talking about credit reporting is where there's two different entities involved in interfacing with the consumer and a different entity that's actually responsible for furnishing the information to the CRAs. And so typically what happens is you will outsource the servicing or the collections to a third party. They're the ones that are communicating information to the consumers about the debt or about the account, and oftentimes the consumers will then lodge the dispute with that third party. Meanwhile, you, the furnisher, are creating the credit report file and furnishing information. Where there's a lag or not good connection between those two entities, the information that's being reported is not up to date or may never be up to date. So, for example, the trade line is not being reported as disputed, or any payments that may have come in to the third party won't be updated fast enough in the credit file. And so it's those type. So think of something like a repossession. If you're in car space, and you work with a third party to do a repo, within hours that there's a lot of activity, and if the credit file doesn't appropriately reflect the status of the repossession, where maybe the furnisher thinks it happened, but actually because you give a consumer 24 hours to kind of stop or interfere the repossession, it actually was not repoed, but the credit report will reflect that it was. And that is one of the most common ways that credit reports end up being inaccurate, because there's just not great connection between the two parties that have different information, and that most correct and up-to-date information is just not getting into the credit report file.
And it's a pretty clear way to get one of the regulators on your back very quickly, because if the consumer's getting the runaround and it's not easy for them to file a dispute and get a clear answer, it will raise the curiosity of the regulators.
So before we move on to a discussion about compliance, which I think has been embedded in a lot of our conversation today, I just wanted to kind of do a quick summary of what we've heard so far. First of all, the Furnisher rule, also called Regulation V, applies pretty broadly to lots of different entities and individuals that furnish information to the credit reporting agencies, including banks, any kind of lender, any credit card company, a collector, perhaps a servicer of debt. And that's really important to understand because of the strictures imposed by the Furnisher rule, the dispute resolution mechanism, the idea that you need to have pretty strict policies and procedures in place. I thought it was very interesting. Alex mentioned something that is unique to the Furnisher rule, which is the actual requirement that policies and procedures exist. One of the few rules I can think of, and maybe the only rule I can think of, that implements a consumer financial statute, that a financial protection statute that actually specifically requires policies and procedures, as opposed to the CFPB or a prudential regulator coming in and examining for compliance on those grounds. So it's important you comply with the Furnisher rule. It's really the mechanism that exists for consumer-facing interactions and for consumers to have the ability to contest that which is on their credit report. In addition, the Furnisher rule has been a long-time enforcement priority of the Federal Trade Commission. It's an enforcement priority of the Bureau for the reasons I just said. I know from my days at the CFPB, I worked in the Office of Enforcement, and very, very early on, from the very beginning of that agency, I was there, and the Furnisher rule and implementation of its requirements has been a top priority for the Bureau. In addition, it's important to understand that the Fair Credit Reporting Act is increasingly a focus of private lawsuits, even if there isn't any obvious damage or injury that could be done to a consumer, or let me put it another way, a monetizable injury. So, you could argue there's definitely injury if someone misreports or misstates something on your credit report, but, monetizing that, showing the specific injury is hard to do, but nevertheless, FCRA has definitely been a source of private lawsuits, and this entire universe of how credit reporting is done has been a source of increasing private lawsuits, and that's something to be mindful of as well, especially if you do find yourself on the wrong side of an enforcement action with a regulator. That doesn't insulate you, of course, from being the potential defendant in a private class action, and in fact might heighten the likelihood of that happening. We've talked a little bit about the direct and indirect disputes as well. Direct disputes being direct consumer disputes to which you have to respond unless they're frivolous. Indirect disputes coming through over the transom through the CRAs, and you have to respond to all of those, even if you're repeatedly responding to what could be potentially the same dispute. And something else that Alex talked about earlier, which was the use of certain kinds of coding, what's called Metro 2 or eOscar, which is the system that transports the codes to the CRA, and Metro 2 is the coding itself. And one of the questions we've received is, can we give an example of instances where a furnisher's non-compliance with Metro 2 coding resulted in some kind of enforcement action? And I have in my mind one action that the Bureau took, which I believe looked at that issue a little bit, because Metro 2 is, of course, a fairly elaborate system, and the failure from the perspective, at least of the CFPB, to perfectly comply with its protocol, was something that they did take action with, an issue with. From the Bureau's perspective, from the Federal Trade Commission's perspective, and from the prudential regulator's perspective, the reason they would care is to the extent that the Metro 2 codes don't translate properly and ultimately result in some kind of misreporting on a consumer report. So there are instances where this is something that the Bureau is looking at. Candidly, I think it's much more likely to come up in the context of supervision and examination, just because it's really one of those things that lends itself more to a memorandum of understanding or a matter requiring attention. But that is something else we've seen. We have a few minutes left, and we're going to talk a bit about compliance and litigation risk and how you mitigate those things in light of what you've heard today. Alex, if you can lead us off with that would be terrific.
Sure. So, of course, the starting point for compliance with any statute or regulation is the establishment of a compliance management system. A CMS's basic goals are to establish compliance responsibilities among the various departments and personnel of an organization. Another purpose is to communicate those responsibilities to employees so that they know what their duties are, ensure that responsibilities for meeting the legal requirements and policies are incorporated into the actual business practices and processes. A CMS also is designed to review operations on a regular basis to ensure that all the policies and procedures are working as expected, and then where issues are identified, as they always will be, that quick corrective action can be taken to address it. And basic elements of a CMS is, first, board and oversight, second, a compliance program, and third, independent audit function. I just want to spend, just a couple of minutes breaking down kind of a compliance program with, keeping, the furnishing practices front and center. And so we'll talk about policies and procedures, which we have already, a little bit more in a minute, but I think the primary, difficulty with respect to managing compliance and implementing policies and procedures on the furnishing is that there's a lot of different business functions that are involved. So, one is a very highly technical, data process that requires creating very large, intensive, complex data files that are mapped to specific formatting and coding standards and then transferred to a third party. And it's a very technical function. And so you have data scientists, analysts, and technical people that typically are responsible for making sure that the files are created and sent, and making sure that they're mapping correctly and therefore accurately being reported. Those folks are very different from the folks that will understand the underlying kind of purposes of accurate credit reporting, very different than the folks that will understand the system of record foundation and whether or not information is being properly updated in the system of record. And it's certainly a completely different business function than those in your organization that will be responsible for investigating disputes. And they're all interconnected. And so I think when you kind of are evaluating the robustness of your CMS, I always encourage clients to engage in a gap analysis, at least on a yearly basis, with respect to furnishing, is that you're looking at all of those areas, the technical folks, your data scientists that are helping you implement furnishing, those that are involved in the investigation of disputes, and then what's bridging those two. And I think making sure that everyone's properly trained to understand, the purpose of the FCRA and what, the accuracy obligations are, has to be translated for those different business functions. And then, of course, vendor management. And then finally, we talked about policies and procedures already. We know it's required under the statute. The one thing I would just kind of add is that, making sure that a quality control program exists at the organization that requires regular quality control of the data itself, not just the files that are going to the credit bureaus, but the actual data in your SOR, that it's been pressure tested, and that it's all the different inputs that update the various accounts that you're working with are being properly incorporated, and especially when you're dealing with multiple systems of records. That typically happens when an account goes delinquent or in default or in collections. Oftentimes it switches systems of record, and that there is a auditing function on the back end that looks at the credit furnishing practices on a yearly or every other year basis. It's something that I recommend. And then finally, this is an area that's very dynamic. It's rapidly changing. As I mentioned, the 3 national credit reporting agencies entered into a large settlement with about 33 states in May of 2015, and all the different requirements are being phased in over the course of 3 years. And a lot of changes are coming out by the credit reporting agencies down to the furnishers, impacting collections, trade lines, medical debt trade lines are going to be very different. And so you need to constantly stay on top of these changes and incorporate them into your policies, procedures, and training. And this includes internal changes. So if you make a change in how you deal with the specific account, the status, if you give a grace period, for example, that you weren't giving before, that impacts your credit reporting. And oftentimes those bridges are not made, and that's where credit reporting issues arise. And so with that, we thank you so much for participating. If you have any questions, please feel free to contact us.
Thank you very